Benjamin, do you want to give a short response to it?
Sure. Emphasis on short. Yeah, I mean, I'll gladly take it on board. It is indeed the case that Grotius was not an accomplished papyrologist, and so I do think it does go very much. It is very much in the vein of say what things like the Lex de Imperio are also talking about on some much higher level of abstraction, and then what Grotius is talking about is that it's still at a further higher level of altitude still, but it runs, as it were, in parallel, I'd say. So, and like Grotius, I have no idea about papyrology, so I'm very glad to learn about it.
Thank you. Further questions and comments? I'm sorry, I can't see the name. But yeah. David. All right, David Bazinas, right.
So it seems to me that looking at your paper for the conference, but also, as I mentioned before, Daniel Lee's manuscript on much the same themes, that there is this process of reception of Roman private law in which Grotius and others are involved. And they try to use Roman private law as a way of trying to understand the state. So it gives them a kind of vocabulary, a new vocabulary for understanding the state, in which they can explore limits on state power. And these limits are meant to be something different from moral limits, and that's, according to Daniel Lee at any rate, they want a kind of science of state power. And because they find Roman private law gives them that vocabulary, they can make the claim to science because it's a legal vocabulary, not a moral vocabulary, even though they might be putting it to moral uses. So there's this kind of interesting reception of ideas from Roman private law, which the Romans did not intend the kind of use that people like Grotius made of their concepts. And then we get a later reception, and this later reception is in a way the topic of our conference. So this is the reception in which Ayal and others are involved. And they're taking these ideas and trying to make use of them in public law. But I think, in a way of taking my cue from what Ayal said earlier in response to a question, it might be that these ideas are now just metaphors, rather than drawing on any distinct private law ideas. So the question is whether we are, in a way, too bound by the private law origins of these ideas in using these metaphors, and maybe we should find better metaphors that don't trail these kind of clouds of etymology from the past.
Yeah, I pretty much agree with the picture you sketched of these various receptions. I would say that for Grotius, it is of course important to have all that etymological or say historical baggage, because that's precisely what he was aiming at, is having a detailed system of legal rules that lend specificity to claims and that are very already very elaborated, and he knew them well as a humanist Roman lawyer. So that's precisely what he wanted. His problem was to justify why these rules should bind sovereigns in the first place. And I also agree that probably now we have moved further towards a metaphorical use of those concepts. And of course, one can get rid of the. I wouldn't argue that one is wedded to the baggage. One can jettison it. I think, as a matter of principle, it's easy to jettison it. But then, the reason why one reaches for these metaphors, is my suspicion, is that there's still actually quite a lot that one likes about that baggage. So that's otherwise one would just make up one's own stuff. But I think there's still a lot to the elaboration of these legal concepts that actually makes them so attractive, even in this latest round of reception. Would be my suspicion.
Hands, please, if you want.
Okay, it's probably following up from the previous question, but perhaps with a slightly different stress. So you make Grotius sound very modern, and I think that's fine by me, in the sense that, a few people interpret it as the founding father of a different conception of modern morality. And yet, you do not address the problems that Grotius faced while introducing this jurally based understanding of morality. Namely, you talk about Grotius naturalism and that human beings are capable of discerning moral principles by applying natural reason. And you claim that Grotius departs from the source theory of obligations, the theory that's according to which God is the source of obligations. But then, the question that remains open is where do these moral principles come from? So it's something that I would like to hear about from you, in the sense that you seem to suggest that Grotius naturalism is absolutely self-standing. Natural reason is capable of discovering these moral principles. But if you do not accept the idea of a source for moral principles, then this idea of naturalism comes apart in your hands. Well, it's hard to actually point out the origin of the moral principles that natural reason is referring to.
Yeah, so there's an answer that in its briefness would even satisfy the friendly moderator. It's basically buy my book when it comes out in the fall. That holds for all of you. and then you will see. But I would say what he does do is revive a pretty specific Ciceronian model of how moral obligations arise by virtue of it's some sort of Roman-inflected Stoicism, I would say. And I think he finds that concept in Cicero, and he finds it much more appealing than the Greek Stoic background that influences Cicero, but the way Cicero shapes this natural law doctrine and also the doctrine of moral obligation appeals to Grotius, not least because it's a doctrine that is amenable of legal expression. That was a reason why it appealed to Cicero as well. And so I think also relatively briefly, I mean, basically you would have to look at Cicero's concept of moral obligation and how he relates it to recta ratio, to that concept of right reason. And I think Grotius takes that more or less one-to-one. And I indeed think, I mean, there's libraries written about whether or not Grotius has any role for God to play in this. And yeah, I come down on one side of this divide, and I think it's more convincing than the other. But
just very quickly, I mean, even if you're prepared to accept this sort of package of jural Roman notions, I mean, what makes them normative? So where does Grotius explain? How does Grotius explain normativity of this package? In the God picture, it's easy because the normativity comes from the will of God. So it's easy to understand that we have to obey certain rules because God says we ought to do so. But in the Grotius new model, allegedly new, we do not understand why this package is normative.
Mm-hmm. No, I don't think it's new. Actually, I think the way that how right reason imposes obligations of a moral kind on all of us by virtue of being human beings endowed with reason, that I think is actually to an extent quite conventional and quite orthodox scholastic doctrine. I think what is new about Grotius' way of using this stuff is that he kind of goes back to Cicero and sees that this can be foisted upon a whole body of legal doctrine. That is the new thing, that he can flesh it out and give some legal specificity to all this. But right reason as a source of moral obligation is not something that he comes up with. I think that's even Thomistic thought is quite a conventional view.
Pass the microphone
up. Thanks very much. I have a picky comment, but then it leads to a more general comment. The picky comment is toward the end of your paper, Benjamin, where you entertain the idea of a combination of Hobbesian sovereignty and Vatelian international society, but basically say, well, except the Hobbes picture won't work because we don't have a sovereign of international order to represent humanity and make humanity a person that could be the principal in a principal agency relation. If I'm interpreting correctly what you're saying here.
We might have the sovereign, but we do not have the people. Or there's no.
Well, no. If we have the sovereign, then we would have the people, because the sovereign could represent the people,
right.
And that creates the people. But we do have that. I don't think that's right, though, right? I mean, because we do have today, in any case, which is what you're sort of talking about. How could this apply today? We do have an international community that delegates to various actors, sometimes to states, the capacity to act in an international role. And to the extent that they're acting in that capacity, they can be said to be acting for humanity, and therefore creating humanity as a person that serves as a principal in that role. That's the picky point. So I don't want to get caught up on that. I think the more interesting point, or the question that I have, has to do with the combining Grotius and Hobbes, because they have fundamentally different understandings of right reason. Right? For Grotius, it's natural. It exists, and private individuals in the state of nature have access to it, can seek redress, and can punish in accordance with it. For Hobbes, that's not possible. For Hobbes, right reason is strictly a public phenomenon, an artificial phenomenon. And I'm just wondering if that if you think that complicates in any way the attempt to wed a kind of Hobbesian superstructure with Grotian bits. If I understood what you're trying to do toward the end.
I mean, on the first more detailed point, I can see how that might work, or I can. So it was maybe a kind of a glib attempt at skepticism. The issue, the concept of right reason and how it diverges in Hobbes and in Grotius. I'm not sure I think the synthesis, if there is any, it's a Vatelian one, and I don't think I wouldn't agree with you when you say that right reason in Hobbes has nothing. There's no role for it in the state of nature. If that was what
that's not what I'm saying.
You were saying.
There is some rule.
Right. It's obviously
we have access to the laws of nature, but they can't. But for us to find justice, we have to go to a third party.
Right. Yes. I would agree with that kind of distinction between Hobbes and Grotius. Unlike, I don't know, people like Tock would think that they were much closer even in this regard. But I'm not sure if Vattel is really a way around that. I think Vattel just shifts, changes that topic a little bit. So, but I'm not trying to combine Hobbes and Grotius for any kind of overarching.
I was wondering, I might be wanting to. So I'm just saying if you think it's plausible.
Well, so let me just ask, I'm not sure, my question, I'm not sure it's really for Benjamin or just for Eyal or just in general. And it's sort of following on what David Deisenhoff said before about, it seems that the property notions have moved to a metaphorical use in Eyal's paper at least. So I'm wondering, so again, this is for you or maybe for Eyal, is property do you see it as the source of limitations on do you see, it seems in the early modern works that Benjamin was discussing, property relations are actually, according to some thinkers, the source of legitimate sovereignty and limitations on sovereignty, like there's actual doctrinal limitations on sovereignty that come out of property relationships. Another way property could be viewed as relating to sovereignty and its limitations is in a purely metaphorical sense, or inspirational in the way that you mentioned Joseph Sachs, is that I'm going to take a notion from property law, trusteeship, and apply it to administrative law, really stripped of all its propertiness, but just as a way of understanding what I think administrative law should be doing. And then maybe a third way you could think about relationship is that property actually imposes limits on sovereignty. I mean, I think part of your paper you were talking about that property rights in the private realm actually impose true substantive limits on sovereignty. Okay, which is a commonplace notion, right, among constitutional lawyers, let's say. But how does that fit into the larger discussion going on here about global trusteeship? Does property, as a private law notion, have a role to play in the global trusteeship conversation? So, if anyone wants to.
Yeah, with your third option with private property actually placing constraints on sovereignty, this is indeed a commonplace, and it's interesting to see that someone like Jean Baudin, who's usually interpreted as an absolutist, he would be the first to say that sovereignty stops where private property of the subjects begins. He wouldn't quite phrase it as Cicero and say this is the reason why we have sovereignty in the first place, but he would acknowledge it as a constraint. And interestingly, he also takes a lot of private contract law rules out of the reach of sovereignty. So I think that there's a huge tradition even within the absolutist camp in early modern political thought that would adhere to such views.
If I can say something, it would be totally historical. I mean,
wait a second, for the mic.
It seems to me that property is a kind of an awkward foil in the sense that from afar, property seems to be very Blackstonian. It seems to be like a very monistic, absolutist thing. And therefore, it is the antidote to the state power. That's the third meaning that you mentioned. But also, on the flip side, is that property is the model that absolute power can be shaped, can mimic. From my perspective, from looking at property from the bottom, from where property is, property takes so many forms that do not necessarily privilege the absolute conception of property, and therefore one needs to be much more specific in order to see whether property can be an effective constraint against power. That's one side. The other side, one should not be surprised to find non-absolutist forms of governing resources, including fiduciary forms, and therefore be much more amenable to the kind of configurations that Eyal is suggesting. So property is a beginning of a conversation that can point out to both similarities and distinctions, as a conversation that both needs to require at least justifications for the claim for certain powers over resources, both a justification from private individuals and from sovereign states, and an acknowledgement that those justifications sometimes entail certain limitations. And I think that one can see both moves in the context of private law theory or property theory, and in the context of thinking about sovereignty and its limits. So I'm not sure. So it may be a metaphor, but I also think that there is a lot of ground for mutual learning in both respects. I don't know if it answers.
So this is a very important topic, the interface between property and sovereignty. So property also creates the same depletion of access to democratic participation, the paper that Doreen and I worked on. But I would suggest that property, maybe counterintuitively, property require more protection, more respect than sovereignty in the following sense, and this is only one sense, which is we know that there's public property and private property. So we have public space, we have commons. We do have commons, and we have private ownership. In the global sphere, if you think about state sovereignty, there is no public space. There are no. The commons are commons that are inhabitable. So you can't sleep on the high seas. You have to have some kind of a ground to stand on, and this is why sovereignty requires more, calls for more other regarding obligations than private property.
Alon.
No, I just wanted to react.
Yeah, just wait for the mic.
I just wanted to react to this last comment. I mean, it could require more. On the other end, it could require an attempt to create a commons on the global sphere, which are two different things. I mean, one thing is to say, okay, so there ought to be greater constraints on.
You have to take it from someone.
Maybe, yeah, I agree, but you have to take it from someone, or you have to take it from all. But once you have a common, that's a great idea, actually, for the vision of the global order, is to have commons on the global sphere. Okay.
Well, I think Andrew's paper will talk about that tomorrow. Okay, so now we have the lunch break. Thank you very much.